So you are a landlord and you know that someday you might have to take a tenant to court and you really don't want to, but you want to be prepared. In this video, we're going to talk about 4 different things: about repairs, about text messages that come up in court, about what paperwork you need to keep, and then about whether you should go for collections in small claims court or should you go right to circuit court for those collections. So let's get into it. I'm Monique Burns. I am a house flipper in Detroit. I also have my own rental properties, and I have also had a property management company. I don't do that anymore. If you're interested in buying a turnkey house from us, set up a time to talk to me on Calendly. We're only selling to cash buyers right now. Another thing, if you really don't want to end up in court, a lot of this can be prevented in the screening. And I do have a free screening questionnaire. You can link below to get that from me. And these are a lot of the questions I go over with somebody before I ever rent to them. So let's get into this stuff. So I am on the board of the Real Estate Investors Association of Oakland County, REIA of Oakland, and it was my turn to lead a panel. And so I picked my own law firm, Aaron Cox Law. We represent a lot of landlords in the whole Metro Detroit area, and I invited them to speak on our panel and give us some pointers about some things that we could do better as landlords. And one of the things we talked about was repairs. And I said to them, as landlords, we really hate doing repairs when tenants owe us money. We hate that. And they said that we have to keep the houses habitable. They have to be, obviously. And then somebody's like, well, someone from the audience, what about carpet? And they said, well, okay, the tenant could make the case in court. I've been here 20 years. This carpet's disgusting. Let's be reasonable here, but you do have to do the repairs, which leads to number 2, text messages. I have noticed that when tenants are on the muscle and they want to move and they're making a point, like especially if they have Section 8 and they're trying to make an abatement happen. And if you don't know what that is, I did make a video about abatements. I'll put the link up here. It means Section 8 stops paying because the landlord didn't do the repairs. But sometimes tenants get on the muscle and they don't let you in to do the repairs. And there's typically communication about this, and it's typically in a text message. Maybe you do it through a portal or you're doing it through email, but in my case, it's typically a text message. And the attorneys said, make no mistake, it's usually the tenants that will print off all the text messages and hand them to the judge. But you should always be prepared that whatever you're saying in text could be printed off and given to the judge. And in our case, when they don't want to let you in for the repairs, at least I can print it off and I can be like, see, we tried and tried to do the repairs, so you really can't hold that against me. And then another thing that I'm not saying how the attorneys are going to rule. I don't know. It was interesting too during the whole case it was interesting too when I was leading the panel. They kept saying, well, in this court, they'll do this, but in this court, they'll do that. And we're talking about the exact same thing. And it's so frustrating to me. And they said, well, it's just, who voted in those judges? Who are the judges working for? And where I am in Detroit, they're probably voted in by a lot of renters because there's a lot of renters in Detroit. Hey, if you're liking this video, it helps me so much if you give it a thumbs up, if you share it, if you comment. I do try to keep up on the comments. I appreciate it. Thank you. But anyway, so then another subject, number 3, that they brought up was paperwork. And obviously, there's all those text messages. You can print that off. That's some paperwork. But they said you keep, if you have Section 8 tenants, you keep the adjustment notification. That's when Section 8 re-evaluates the tenant's income and says, okay, we're going to pay this much and the tenant's going to pay this much this time. So keep those. And you have to keep any abatement notices. And the abatement notices, the reason you're keeping them is there's a date on there that after this point of time, the house is in abatement, meaning that the tenant is responsible to pay the rent after a certain point of time. Don't quote me on that. You need a lawyer for this little piece of it. But then there's the intent to vacate, and that's another form from a tenant, and it shows when the relationship is over between Section 8 and me and the tenant. So meaning that Section 8 is no longer paying. You need those dates in case that's something the lawyers need to fight for you. So now number 4, the difference between the different courts. So landlord-tenant cases are heard in district court. And then if the tenant owes us money, we can go to small claims court, and there's an amount in each state, it's different, I think, but of money that small claims will do for us. So if the tenant owes any more than this amount, you wouldn't go to small claims court, because that's the limit that they owe, that they do in Michigan for small claims. You would take it to circuit court to get the full amount if that's what you're going to do. Well, small claims court, the deal with small claims court is you don't need an attorney. So us do-it-yourselfer landlords are like, yeah, I'm going to small claims. I'm not paying an attorney. I'm going to get my right judgment. Well, good luck collecting on that judgment, because somebody brought up the question to the attorneys during the panel, and they said, can I give you my small claims judgment, and then will you collect on my tenant using that paperwork you said and proving those dates and things? And they said no, because the deal with small claims is there's no attorneys. So if you don't do small claims, even if it's a smaller amount, less than the small claims amount, and you're leaving it up to the attorneys, they're going to circuit court. And the thing that was super interesting to me is I'm always thinking it's so unfair in landlord-tenant court what goes on. And they said, oh no, circuit court, that's all contract law. And so they're really interested in what's in your lease. They're interested in the intent to vacate, the abatement notice, the adjustment notification. Circuit court wants all that information because it's all straight up contract law. And that's where you get your judgment. And then once you get the judgment, you use the attorneys to go after things like garnishing their tax returns or their wages or whatever all they do. That's not whatever they go for. I don't really have a lot of experience going this far with it with tenants. For one, I didn't realize how successful I could be in circuit court. For two, I'm like, are they even collectible? Even if I did win it, like they're living off the system. How am I even going to collect it then? But apparently a lot of these attorneys are able to get that money. So, and for three, I do a really good upfront screening. And I'm a big believer in going to see how they live before they come move into my house. But all the screening I do that I pour my heart and soul into, we can still get bad apples. I mean, it can still happen where we get a tenant that just won't do what they're supposed to do. So it was interesting learning all this, and it's good to have a good law firm. And I'm really happy. Whoa. I'm happy with the one I have. Thank you for watching. So I'm leaving this in at the end of the video because this is what I go through trying to get a thumbnail, because I can never get my eyes to open all the way. And so I thought maybe you could laugh along with me as I am struggling so hard to open my eyes and make the correct facial expression for a thumbnail.